Hi guys, good night. My name is Alina Shaltsova. I'm an immigration attorney from Brooklyn, New York. We tried to hold this event last night, but I know some people had trouble joining us because of the format that we were doing it. So we decided to repeat it tonight as well. And today we're going to be talking about waivers and specifically provisional waiver. Waivers are pardons granted by United States government or by USCIS to those who were found deportable or inadmissible, and for any reason. It can be a criminal reason, can be a reason person violated immigration laws, overstayed their visas, or they entered the country unlawfully, or lied, or were found committing misrepresentation when they were submitting their paperwork. We're going to focus on I-601A Provisional Waiver. I-601A Provisional Waiver is a relatively new measure. I would say it's a part of President Obama immigration reform or steps towards immigration reform. And it's been implemented in March of 2013. Surprisingly, even though 2 years passed, some people do not know about this. I-601A waiver is a tool that cures or helps to cure illegal entry to the country or entry by crossing the border. How does it do it? Well, basically, when somebody crosses the border, he or she, in most situations, would not be able to get a green card in the United States. There are exceptions to this rule. Let's say if somebody crossed the border and subsequently a petition was filed for this person prior to a certain date, April 30th, 2001. Usually we use this date because it's more recent. If family petition or labor certification was filed for the person by April 30th, 2001, even if the person crossed the border and in the regular course of things would not be able to receive his green card. In this situation, if the petition was filed or labor certification was filed and we can find proof of that, the person will be able to get a green card if now he or she has basis for that. And by basis, I mean family petition or work petition. It can be work petition as well. Let's say somebody is unskilled worker, somebody works in a store, and that store filed for the person many, many years ago, and now there is time came for the person to receive his green card. If no petition was filed for the person and the person entered the country illegally, this person would not be able to get a green card, even though the petition is current. However, if the person, let's say, crossed the border in 1994 and by April 30th, 2001, the person was petitioned by anybody but never actually used the petition because for whatever reason it didn't work out. Now this person, based on a new petition, will be able to get his or her green card. The person will go through adjustment of status based on Section 245I, and will have to pay a fine of $1,000 together with other filing immigration fees. Now, that's one of the exceptions for somebody who crossed the border illegally. Another so-called exception, it's not really an exception, but it's rather a situation when somebody is crossing the border and not by just crossing it somewhere, but let's say they were in a vehicle and crossed United States border with Mexico, and there was a US citizen in the car who transported that non-citizen into the United States. And when they were in the car crossing the border, the CBP officer, the officer at the border, did not ask a non-citizen if he or she was a citizen, but rather referred only to the driver, and as the driver saying, hey, you know, who are you? Of course, like, are you a citizen? And the person said yes. And the CBP officer just assumed that the other person or other passengers in the car are also citizens and did not check the documents. And that's how non-citizens got into the country. That is also, believe it or not, illegal entry. It's much harder to prove because the non-citizen will have to remember little details of the trip and who was the person who was transporting him or her and all of the circumstances. But if you're in immigration court, for example, where you can talk to the judge and establish that it's called a waive-in exception happened, then you will be able to get your green card. Because what happened here, a non-citizen was inspected and admitted into the United States, and this is what we need to get a green card. Well, what if we cannot prove all this and nobody petitioned for us and we did not waive in, but rather just entered the country somehow? And now, many years since, let's say the person got married to a US citizen. The person tried filing the documents and the petition, of course, got denied. Our adjustment of status application got denied because the immigration said, well, sir, you were not inspected or admitted, madam, and that's why you cannot get a green card in the United States. This was a situation for many years in the United States, and the only way the person would be able to go around it, it's either to go through a cancellation of removal with an immigration judge in immigration court, and for that the person would have to ask immigration to start removal proceedings against him or her, and then defend himself or herself in front of the judge, saying that they have been in the country long enough, even though they entered illegally, and now they have U.S. citizen wife or husband, and they should be able to stay in the country because that person will experience extreme hardship in case they're not allowed to stay in the country. That was one of the possible solution to it. And another possible solution was to leave the country, go for an immigrant visa, and then once the immigrant visa is denied, because the minute the person leaves the country, he is subject to an unlawful presence bar, because the person did stay illegally in the country for many years. And only after the person is denied, then the person would apply for a waiver. It's called I-601 waiver. Very similar, but without A. Unfortunately, the situation would cause lengthy separations between the families, because after one files for I-601 waiver, I believe except for Mexico, there were very long delays in adjudication of the waiver, and it would take literally years before a decision is made on the application for the waiver. And of course, it was a very difficult situation, and that's why I think this present administration, they finally proposed a resolution to the situation, even though not ideal, but it is something. Basically, what they said is, if somebody has only one problem here, is that they entered the country illegally, and now they have a U.S. citizen spouse, or parent, or child. If they qualify to be an immediate relative of the U.S. citizen, that's the current version of it. If they qualify to be an immediate relative of the U.S. citizen, then they can apply for a waiver before they leave the country. They will still have to leave the country, but they can apply for a waiver before they leave the country and wait for the waiver's result before they leave the country. And guess what? If the result is not positive, the person probably will never leave the country and will wait for something else. So that's what I-601A waiver is. And this version of it was in 2013. Now, I believe they would like to expand it a little bit. and allow not only relatives of U.S. citizens but permanent residents apply for the waiver as well. Another important change that came is that current administration would like to set a presumption of hardship. If before we had to show extreme hardship in each and every case, and we will discuss how we do that. Now they say, let's say we agree that if the couple has been together for 3 years, we will recognize by default that there will be extreme hardship found if the couple is separated. That's what a presumption is. It means that if you establish one fact, the second fact is assumed. I do not believe this is implemented yet, but they do want to do that, and it's good. Because extreme hardship is not so easy to prove. What's necessary for that? Well, extreme hardship by law, it's something more than just regular hardship or regular bad mood if your husband or wife is being sent out of the country. It's rather a complex or set of different factors that one needs to come up with and convince the person who is adjudicating the waiver, who's never seen you, never going to see you in person probably, that you will or your spouse will suffer a lot if non-citizen is removed from the country. Number one, medical issues. If a U.S. citizen has a medical condition that prevents him to move out of the country, that the non-citizen is helping him or her on a regular basis, this is a very strong argument in favor of extreme hardship. What can it be? Well, it can be some kind of trauma that a citizen sustained and has to undergo regular treatment, or maybe is partially or fully disabled as a result of that. And disability does not only have to be physical, it can be all kind of disability recognized by law. It can be financial hardship, even though online you will find that, well, financial hardship is not a very strong factor. In each case that we filed, and in each case that I read decisions on, every time USCIS asks for bills, proof of income, proof of how much the person non-citizen is contributing, if any, to the common household, and what in fact financial hardship will occur if non-citizen is removed from the country. So that's a very important factor. Somebody who's applying for a waiver will have to do a good job documenting all the bills, all the invoices, grocery receipts, rent receipts, debt, credit card debt, mortgage. Maybe somebody's filing for bankruptcy. It's all very, very important. One way to show this financial hardship is to say, well, you see, I have a mortgage, and my mortgage is $3,000. If I move to Jamaica with my spouse, according to the statistics, I will be able to make only $400 a month. There is no way I'll be able to pay off this mortgage. It means that I will lose my house, and it is financial hardship because house means a lot for Americans. It's, you know, American dream to have their own home. One thing to do that. Another way is to say that, say somebody has a child in college and they say, listen, my child could not qualify for scholarship, I have to pay tuition. If I move to Jamaica and let's say my child is not a little, not a minor, but let's say 20 years old now, but still I will not be able to cover, excuse me, cover the bills, because the bills will amount to, I don't know, $2,500 per semester, and with my salary or proposed, if I find a job in Jamaica, of $300 a month will not be enough to cover anything. So that's financial hardship. And as I said, credit card debt. If somebody can show that, you know what, I already have $30,000 in debt. If I move anywhere outside of the United States, and it looks like I will not be able to find a job there, or the job there will pay very little, there is no way I'm going to be able to pay $30,000 back. So somebody is going to sustain hardship here, maybe credit card company. So that's another important factor, financial factor. Education for the kids, very important. If you have minor children who are accustomed to live in the United States and who have never been or rarely been into foreign country, and they will probably have hard time adapting in the foreign country for whatever reasons, that's another very important factor for the hardship. Each situation, each case is different. To come up with a strong case, we usually sit down with a person and we first talk for an hour, 2 hours, asking different questions to see what's going on in the person's life, why it's so important. And I usually ask my clients, I say, explain to me in your own words why it's so important that this person stays with you. Because I know it's important to you, but we need to explain it to somebody who has never seen you and will never see you. And just saying that, you know, I love my husband Ralph, or I love my wife Maria, it's not going to work nowadays. You have to be specific. Why do you love Maria? Why Maria is so important to you? Why you do not see your life without Maria? So, and you know, the cases that I filed, if you speak to people, most of them, they are compelling stories. Somebody, you know, cannot go back to whatever country they came from because, let's say, they have a same-sex marriage and that country is very against gay people. That's no, nobody can go back there. Not the couple, not the person who got married here, not the children. Somebody cannot move back to whatever they came from many years ago. Sometimes, let's say, we have a situation where the spouse is originally from the same country as a non-citizen, but the spouse has lived here for, let's say, 25 or 30 years and does not have connections with that country anymore. Extreme hardship was found in these cases as well. Because the way the government looks at the waiver, they say, okay, first step, we're going to see why the U.S. citizen cannot move with a citizen to whatever country the U.S. non-citizen will be removed to. And we need to present compelling arguments why. And then they say, okay, maybe the U.S. citizen in fact cannot move together with a citizen. So, but it doesn't prove that the U.S. citizen really needs non-citizen. How do we show that? And that's where we explain that non-citizen plays instrumental, very important part in a citizen's life. But guess what? Even after you went through all the steps and you proved your hardship, there's one more thing that United States government is looking at. They basically look at it and say whether we like you or not. It's called discretion. They take into consideration everything. They say, well, it's not applicable to I-601 waiver, but very often when you file for fraud waivers, they say, well, even though Maria really used a fraudulent document when she entered the country, it seems that she really regrets it. And she has 4 children in the United States, and her husband is a nice guy, and she helps in the church. So we think Maria deserves this waiver. Sometimes they say, well, you know, Jose used a fraudulent passport when he entered the country. And to this day, he does not admit that he did that, even though there are evidence to the contrary. So you know what? We think he did not regret about his mistakes, so he is not deserving. Okay, he does not deserve the waiver. It's called discretion. For I-601A waiver, the waiver will be granted if one establishes hardship only if the person is not deportable or inadmissible on any other grounds. If somebody has a second problem to unlawful presence or illegal entry in the form of criminal conviction or fraud or claims of citizenship, they don't even have to bother to waste their time and money filing for I-601A because it will be denied. There are clear guidelines from USCIS saying that if the officer has a reason to believe that there are other applicable grounds of inadmissibility, I-601A will not be granted. It means that the person has to find a different way to stay here. Sometimes, as I said, it can be cancellation of removal. Sometimes it can be a different waiver. There is a traditional waiver called I-601 waiver. That waiver actually can waive many different things. I mean, it's tricky a little bit, and many people do not understand why we talk about different waivers, but they're all called I-601. It's because they're filed in the same form. The government, rather than issuing special form for each special category of inadmissibility, they said, you know what, we're going to use a couple of different forms for a couple categories of problems. And I-601 form, this is a form that can, if you read it, and you can find it at www.uscis.gov, you will see that it has different basis for bars to inadmissibility that a person can ask to be waived. Another popular form is I-212, and it's used in different situations, but that's another popular waiver. So, how one files for I-601A waiver, and when is it possible? Well, there is a very important condition for filing of I-601A waiver. A person has to have his immigrant visa interview scheduled at a United States consulate overseas. It means that I-130 has to be filed for the person. Petition to recognize that person an immediate relative of the U.S. citizen. And then the case has to be sent to the NVC, National Visa Center. And National Visa Center has to submit an invoice for the immigrant visa fees and for affidavit of support fees. And those fees must be paid before I-601A can be filed. And then the interview has to be scheduled. And only at that point, a person can file for the waiver. So there will be some more hoops to go through before a person can actually file the waiver. There are certain restrictions for filing I-601A. The law says that somebody who had their immigrant visa interview scheduled prior to a certain date cannot file for the waiver. And there are ways to go around this. In the notice that accompanied the law, in instructions to that notice, it was actually said that if the registration with the Department of State of the immigrant visa interview was terminated, then it is possible for the person to file for I-601A, meaning that the person will have to refile, or I-130 will have to be refiled for the person, and a new interview will have to be scheduled. So far, we had a couple of cases like that, and they were successful, but because everything changes by the minute, I cannot guarantee that it's going to stay the same. Because the government constantly re-evaluates its policies and how it approaches cases. So it can be that tomorrow they're going to say, you know what, it's kind of a loophole and you shouldn't be doing that. So I cannot guarantee that it can work further. But that's one of the ways to go around it. Another way, of course, is to file for traditional waiver. But as I said before, there is a great risk that the waiver might not be granted for a very long time. And the person who is leaving the country will get stuck overseas for a very long time. I would say that I would go through the questions. So if you guys have questions, I would be happy to answer them, and you can submit them now. All right, here is a question. How much does it cost to file for a waiver? Well, a waiver package, you have to file a visa. You have to file, or your relative will have to file as I-130 petition. So it costs $420. Then there is a fee for the waiver, and immigrant visa fees will have to be filed, of course, and paid. I believe currently immigrant visa fee is $230, and there is affidavit of support fee of $88. And then there are lawyers' fees if you'd like to hire an attorney, and those fees depend on each case, on each lawyer. You would have to discuss it with an attorney who's going to be handling the case. But I'm going to tell you that if somebody says that I'm going to handle a waiver for $1,500, it's not going to happen. A lawyer typically charges about $300 per hour. It means that that person who's promising you $1,500 job is going to spend the most 5 hours in your case, and it's just not enough. Because any practitioner who is dealing with waivers is going to tell you that a good, successful waiver is going to take approximately 40 hours to complete the waiver. All right, I see some questions about the personal cases, so I would not be able to answer them now. And you can visit my website, www.shautsova.com. It is SHAUTSOVA.com, and I will be happy to answer questions about particular cases via personal messages. So thank you very much for being with us today, and again, if you have any questions, you can contact me at www.shautsova.com or by calling my office 917-885-2261. Thank you.